picture the scene. It is 2022, and federal agents are just descending on a family home in the Dallas area.
Wow.
Right? We're talking a massive coordinated search warrant. They are turning the entire place upside down because they genuinely suspect they are dealing with a terror cell.
Yeah, and I mean, in those situations, the tension is just unimaginable. The government believes they are actively disrupting a serious organized threat to national security.
Precisely. But the homeowner, a man named Ali Daniel Hamani, he's completely cooperative. He doesn't panic at all. He just complies with every single order. He surrenders a standard pistol he keeps in the house for self-defense, and then he voluntarily points the federal agents to a personal stash of about 60 grams of marijuana on the property.
Just completely upfront about it?
Totally transparent. During the interview, he casually admits to the agents that he uses the drug, quote, about every other day.
And spoiler alert for anyone listening, after all that intense buildup, they find absolutely zero evidence of terrorism.
None.
No terror plots, no international funding, not even like a low-level drug trafficking ring. Just nothing at all.
Nothing. Hamani is literally just a guy who owns a gun and smokes weed in his own home. But, the story doesn't end there. Over 6 months later, the federal government returns.
Because they couldn't make the terror case stick.
Exactly. Since they couldn't make a terrorism case stick, they hit Hamani with a standalone federal charge carrying up to 15 years in federal prison, plus a lifetime ban on owning a firearm. And this wasn't for violence, it wasn't for trafficking. It was solely because he is a gun owner who uses marijuana. They charged him under a specific statute, 18 U.S.C. Section 922 G3, that just strips you of your Second Amendment rights simply for having the status of an unlawful user of a controlled substance.
It really is a profound legal collision. I mean, you have this massive intersection of modern drug habits, fundamental constitutional rights, and frankly, the overwhelming power of the federal bureaucracy trying to define exactly who gets to participate in those rights.
It is. Now, before we dive into the actual mechanisms of that legal collision, a quick note. If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications.
We also have a very quick news update on the Martin Stevens versus OpenAI situation. For those of you tracking the dispute, Stevens has officially suspended his quiet period.
Right.
Yeah, and this comes immediately following OpenAI's June 8, 2026 confidential S1 filing, which, for context, is the massive registration form a company has to submit to the SEC before going public. Stevens publicly characterized moving forward with that filing as a mark of extreme disrespect.
And he has stated unequivocally that he refuses to re-enter a quiet period without a formal binding agreement in place. As of right now, no settlement talks are public at all.
Yeah.
However, it is really worth noting that his dead man switch is currently inactive. Normally, a dead man switch is an automated release of information that triggers if a person fails to log into a system every 24 hours. The fact that his switch is inactive means he deliberately logged in and paused it himself.
Which confirms he's okay.
Exactly. It confirms that he remains in control, physically safe, and legally secure. We will, of course, continue to monitor that situation.
Definitely. Now back to our primary focus for today.
Welcome to The Debate. Today, we are dissecting the Supreme Court's unanimous 9-0 decision handed down on June 18, 2026, in the case of United States v. Hamani. The court officially struck down the federal ban on firearm possession by unlawful drug users, specifically as it applied to Hamani.
Now, the central question this case really forces us to confront is this. Does this unanimous ruling appropriately protect the constitutional rights of sober citizens against overbroad government bans, or does it rely on an entirely unworkable historical test that exposes massive, dangerous gaps in modern public safety?
I will be arguing that this ruling is an absolute necessity. It aligns perfectly with Justice Gorsuch's narrow majority opinion and the Fifth Circuit's really vital Connolly precedent. To me, it is a necessary defense of the Second Amendment rights of sober, nonviolent citizens who have just been unjustly targeted by an overreaching federal bureaucracy.
And I will be arguing that while Hamani himself might be a sympathetic figure,
The underlying legal framework the court used to exonerate him is fundamentally flawed. Echoing Justice Jackson's concurrence, I believe the Bruin historical test forces judges to act as amateur historians, which severely cripples the government's ability to protect the public from genuinely dangerous habitual offenders, a reality that was starkly illustrated by the Fifth Circuit's dissent in the Mitchell case.
Well, let's start by looking at what the government was actually trying to do to Ali Hemoni, because it was, without question, an unconstitutional overreach. Under 922 G3, the government essentially argued that the moment you become a user of a controlled substance, your Second Amendment rights just evaporate.
Right.
But notice what the mechanism of that law leaves out. There is absolutely no requirement to prove you are physically addicted. There's no requirement to prove active intoxication while handling a weapon. And crucially, there is no requirement to prove that you are actually a danger to yourself or anyone else. Hemoni was stripped of a fundamental right simply for his status.
The government's reading of the statute was incredibly broad. I'll definitely grant you that.
I mean, broad is an understatement. It was absolute. And that's why Justice Gorsuch's narrow majority ruling properly rejected the government's desperate attempt to equate modern, occasional marijuana users with colonial-era habitual drunkards.
Which was a stretch.
A huge stretch. The court leaned heavily on the logic from the Fifth Circuit's United States v. Connolly decision, because Connolly established a very practical distinction. Yes, historical laws absolutely supported disarming someone who is actively intoxicated. If you are currently drunk or currently high, you obviously shouldn't be handling a firearm. That is just common sense.
Right. No one is arguing with that.
But our history and tradition never supported permanently disarming a completely sober citizen solely based on habitual or occasional drug use in the privacy of their own home.
Look, I completely acknowledge that Hemoni's specific case makes for a highly sympathetic defendant. He wasn't hurting anyone, he was fully cooperative during a frankly terrifying SWAT raid, and the government essentially weaponized a victimless drug status to threaten him with 15 years in a federal penitentiary. I mean, that feels wrong to most people.
Because it is wrong.
But we have to look past the defendant and examine the legal mechanism the court used to reach this conclusion. They relied on the Bruin's history and tradition test, and as a framework for modern jurisprudence, it is completely unworkable.
Wait, let me make sure I fully understand Justice Jackson's critique here. Are you saying she thinks the courts are completely stripped of their ability to look at modern crime statistics or public safety needs at all?
Exactly. That is the core issue here. Under the standard way courts used to evaluate these laws, which is called means and scrutiny, a judge could look at the law and ask, is banning guns for users of hard illicit drugs a practical, tailored means to achieve the end goal of a safe society? If the answer is yes, the law stands.
Right, a balancing test.
But under the Bruin framework, practicality doesn't matter anymore. Modern data doesn't matter. The Bruin test forces federal judges to put on blinders and act as amateur historians. It forces them to sift through centuries-old colonial records, local town ordinances from the 1700s, and obscure legal treatises just to validate a modern safety law.
But how did the government even try to justify disarming Hemoni in the first place? I mean, they had to look backward to defend the law, right? What was their actual historical argument?
They pointed to three categories of colonial-era laws: vagrancy laws, civil commitment statutes, and surety laws. They essentially argued, look, the founders locked up the town drunks and took their guns, so we can take guns from modern drug users.
And that's exactly where the government's argument completely collapses. Because if we actually look at how those historical laws functioned, it proves exactly why the Bruin test works to protect liberty. Take surety laws, for example. In 1791, if you were the town drunk, the local sheriff didn't just kick in your door and confiscate your musket based on a rumor.
Well, obviously the procedures were different.
But the procedure is the point. A neighbor or a family member had to go before a magistrate and swear under oath that you were an active threat. The magistrate would hold a hearing and demand a surety, basically a financial bond. If you kept the peace, you kept your gun.
Okay, so you're talking about individualized adjudication.
Exactly. As Justice Alito pointed out so clearly in his concurrence, none of these colonial laws operated like a blanket federal ban. They didn't automatically strip everyone who regularly consumed alcohol of their constitutional rights. They specifically targeted individuals whose use of intoxicants rendered them a proven, adjudicated danger to themselves or society. Status alone was never enough. The historical record demands individualized proof of danger.
I'm sorry, but I just don't buy that. Let me tell you why. The entire premise of requiring a perfect historical analog from the 18th century to govern modern society is fundamentally absurd. We are talking about a historical standard crafted in an era where the Founding Fathers had absolutely no conceptual framework for modern pharmacology.
They understood intoxication, though.
Intoxication from ale or rum? Sure. But they didn't know what Schedule I classifications were. They didn't know about drugs the modern government defines as having zero medical use and an extremely high potential for abuse, like heroin or synthetic fentanyl.
But human nature, the tragedy of addiction, and the fundamental right to self-defense haven't changed at all.
The human brain hasn't changed, but the context has changed exponentially. Let's use an analogy here. Relying on the court's historical test is like trying to regulate a modern 18-wheeler going 75 miles per hour down an interstate using the safety rulebook for a horse-drawn carriage.
That's a bit extreme, isn't it?
No, it's accurate. The carriage rules don't account for combustion engines, massive momentum, or highway speeds. Similarly, colonial laws do not account for the psychosis induced by synthetic methamphetamines, nor do they account for the lethality and fire rate of modern semi-automatic weapons.
That's an interesting point, though I would definitely frame it differently. The reason we demand a historical analog isn't because we think the 18th century was technologically identical to today. Obviously, it wasn't. It's to ensure the government cannot invent new, arbitrary reasons to bypass the Constitution whenever it feels like it.
But under this ruling, we are treating the Constitution like a time machine rather than a compass. We're acting like it only protects us if we can find an exact mirror of our modern problem in the past, rather than using it to guide us on modern principles of safety and liberty.
Okay, well, if you want to talk about arbitrary government action and why we need strict historical boundaries, look no further than how the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, was actually enforcing this law before the Supreme Court stepped in. The disconnect between the statutory text and bureaucratic enforcement had become a massive crisis.
You're referring to the NICS background check data, right?
I am. When you go to buy a firearm, you fill out a federal form and your name runs through NICS, the National Instant Criminal Background Check System. The ATF recently had to issue an interim final rule to revise their definition of an unlawful user. And why? Because they were getting crushed by the reality of their own overreach.
Right.
In fiscal year 2025 alone, the NICS system denied over 9,000 firearm transfers under the 922G3 prohibition. And here is the staggering mechanism behind that. Over 4,200 of those denials were based on a single-use inference.
But wait, how is NICS getting that data? It's not like people are just volunteering on the form that they used drugs once?
Often they actually are. Or NICS is pulling from state-level databases. If you applied for a medical marijuana card in your home state, or say if you had a single misdemeanor drug possession ticket from 11 months ago that got shared to the federal database, the federal government automatically deemed you an unlawful user, a single instance. The ATF's own internal enforcement guidelines show they wouldn't even bother trying to retrieve firearms or prosecute based on these single-use inferences because they knew it wouldn't hold up in court.
Yep, they didn't have the resources for that.
Exactly. Yet they were permanently chilling the constitutional rights of thousands of citizens based on mere administrative inferences. I mean, this absolutely justifies the court's strict intervention.
See, I come at it from a completely different way. The ATF's scramble to revise the rule proves exactly why means-end scrutiny is so desperately needed in administrative law. The ATF looked at the background check data, recognized the flaw in targeting single-use inferences, and tried to refine the rule to focus on regular and recent use. That is precisely how government is supposed to work. An agency tailors its enforcement to meet the statutory goal without being overly broad.
I'm just not convinced by that line of reasoning because under the Constitution, a federal agency shouldn't have the authority to just invent and adjust the standard for stripping a fundamental right on the fly.
But look at what the Supreme Court's absolute rejection of status-based bans has done in response. Because the court demands this rigid historical horse-drawn carriage test, even habitual, heavy users of hard drugs cannot be categorically disarmed. The government can no longer say you are a daily user of methamphetamine, therefore you cannot buy an AR-15.
Because status alone isn't enough.
Right, and the result is so extreme that it created bizarre political alliances in this case. You had the ACLU, the NRA, and NORML, the National Organization for the Reform of Marijuana Laws, all uniting on the exact same side, while leaving public safety advocates completely powerless. When the NRA and NORML are cheering together, it usually means the government's regulatory authority has been entirely gutted.
I see why you think that, but let me give you a different perspective on the public safety argument. No one is saying dangerous people should have guns. What the court is saying is that if a drug user is truly dangerous, the government already has the legal tools to prove it in court. Disarmament must be based on individualized proof of danger or present intoxication.
In a perfect world, sure.
If someone is violent, charge them with a violent crime. If they are actively high while carrying a weapon, charge them under state intoxication laws. But you cannot use a blanket assumption that all users of a scheduled substance are inherently dangerous.
That sounds perfectly reasonable in a sterile academic environment. But let's look at how this actually plays out in the real world. Let me introduce the Fifth Circuit's United States v. Mitchell case, because it vividly illustrates the severe public safety hazard this ruling creates. Mitchell was not a casual, peaceful user like Hemeny.
Okay.
Mitchell was an admitted habitual marijuana user, but he also had a deeply troubling history. He was originally convicted under 922G3. But after the Bruen decision, he challenged his conviction, and because the government couldn't find a 1700s historical analog for disarming a habitual drug user, his conviction was tossed out.
Because the law was unconstitutional as applied to him.
Of domestic violence. The record showed he had physically choked the mother of his child. While on supervised release, he explicitly threatened to shoot and kill her. Yet the rigid Bruen test completely blinded the court to Mitchell's actual dangerousness.
Wait, how did it blind the court? If he was a known domestic abuser, why couldn't the judges factor that in?
Because of the legal gymnastics required by originalism and procedural rules, the court was bound by what's called the rule of orderliness. That's basically an appellate court rule saying a three-judge panel cannot overrule a previous panel's decision.
Right. They had to follow precedent.
Yes, they were locked into the Canali precedent, which meant they were forced to look only at the historical analog for the specific predicate drug offense, the 922G3 charge. Because the drug charge didn't have a colonial twin, the disarmament fell apart. The judges could not legally factor in his violent misdemeanors or his domestic abuse history to justify the federal ban. The Bruen test forced them to ignore his violent reality in favor of historical purity.
That is a compelling point regarding the frustration of the judges, but it conflates two entirely different things. The flaw there isn't the Second Amendment. The flaw is how the local jurisdiction handled his domestic violence. We cannot preemptively strip fundamental constitutional rights based on a generalized fear of future violence. Nor can we use a victimless drug status offense as a backdoor mechanism to disarm a domestic abuser.
But the federal government uses these predicate offenses precisely to catch dangerous people who slip through local cracks. Local prosecutors are completely overwhelmed.
And that is exactly what the Constitution forbids. The justice system must prosecute the violent acts themselves. If Mitchell chokes someone, he should be in prison for assault. If he is subject to a domestic violence restraining order, he can be legally disarmed under a totally different statute, 922G8, which, by the way, the Supreme Court explicitly upheld in the Rahimi case.
Yes, but
you do not get to say, well, local police couldn't make the assault charge stick, so we'll just throw him in federal prison for 15 years because we found a joint in his ashtray. That is an abuse of power. The government was using 922G3 as a catch-all net, and it was catching peaceful people like Ali Himani right alongside dangerous people like Mitchell.
that is a very strong defense of due process. But have you considered the administrative burden this places on the state? You are essentially demanding that the government prove individualized dangerousness in every single instance before preventing a firearm purchase. The NICS background check system isn't a courtroom.
It is designed to be an automated categorical filter to prevent tragedies before they happen.
But that's the danger of automated filters when it comes to rights.
If we abandon categorical bans for habitual users of illicit narcotics, we're essentially saying the government must wait until the drug-induced paranoia results in a shooting before they can act.
But that statistical, automated approach is exactly what leads to over 4,200 innocent people being denied their rights in a single year over a single positive drug test. Where does it end? If we allow broad statistics rather than individual due process to dictate constitutional rights, what other groups can we statistically justify disarming?
It's not about arbitrary groups, it's about illicit narcotics.
But the beauty of the Bruin Standard, despite its rigorous demands on judges, is that it sets a definitive floor. It tells the legislature, look, you cannot innovate new ways to deprive people of their rights just because it's administratively convenient. If you want to disarm someone, prove they are actively intoxicated or prove they are dangerous, just as the founders would have required with the surety bond.
The founders also believed in bleeding out patients to cure fevers. I simply cannot accept that their lack of imagination regarding modern pharmacology and modern weaponry should permanently handcuff our legislatures. The Himani decision might feel like a victory for individual liberty, but by tying that victory to the Bruin methodology, the court has essentially guaranteed that we cannot proactively govern public safety.
Well, let's look at where this leaves us. To summarize my position, the unanimous Himani decision rightly puts an end to a decades-long constitutional infringement. For too long, millions of peaceful Americans were threatened with up to 15-year prison sentences and lifetime disarmament simply for smoking marijuana in the privacy of their own homes. The Second Amendment is not a second-class right. It protects all Americans. If the government wants to restrict that right, it cannot rely on bureaucratic inferences, state registry databases, or blanket status bans. It requires what our justice system is supposed to require: proof of active intoxication or specific adjudicated dangerousness.
And to summarize my perspective, while the specific outcome for Mr. Himani may be just because, frankly, nobody wants to see a cooperative citizen imprisoned over a casual marijuana habit, the court's continued reliance on the rigid Bruin historical test is a massive vulnerability for public safety. Justice Jackson's warning remains incredibly potent here. By treating the Constitution like a time machine instead of a compass and abandoning means-end scrutiny, the court has left modern legislatures unable to tailor common-sense laws. We are stripping the government of the tools it needs to prevent firearm misuse by truly dangerous, habitual offenders, all to satisfy an impossible standard of historical purity.
It is absolutely clear that the intersection of modern drug policy, fundamental gun rights, and historical originalism will continue to generate immense legal friction. How lower courts will interpret and apply the standard of dangerousness moving forward will undoubtedly be the next great battleground in Second Amendment law.
Absolutely. We will definitely see many more cases testing the boundaries of exactly what constitutes a credible threat to physical safety in a very modern context.
Because when the diagnostic machine of the law is broken, we are left looking at the murky waters of history, trying to decide if the cure is worse than the disease.
Well said. There is certainly plenty more to explore here.
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications.